Stairway Accident Lawsuit, New York. Your premises liability rights. Attorney Andrew M. Stengel. Stairway Accident Lawsuit in New York. Holding building owners accountable. Stairways are among the most common sources of serious injury in New York buildings. Every year, thousands of New York City residents suffer broken bones, head trauma, and spinal injuries on poorly maintained stairs. Many of these falls never had to happen. Owners often skip routine maintenance until someone gets hurt. A stairway accident lawsuit lets New York survivors hold the building owner accountable. In New York City, that lawsuit runs through state Supreme Court under premises liability law. This post explains the building code requirements, notice the non-delegable duty rule, and damages. Most importantly, it shows why moving fast matters. New York City Building Code requirements for stairways. The New York City Building Code imposes detailed requirements on stairway construction and maintenance. These standards protect residents and visitors from preventable falls. Specifically, the code sets minimum tread dimensions, handrail specifications, lighting levels, and surface standards. Multiple dwellings also fall under the Housing Maintenance Code, which adds its own stairway rules. Furthermore, owners must keep handrails securely fastened. Stair treads must meet precise depth requirements to prevent trips. Lighting must give adequate visibility at all hours. When owners ignore these standards, injured people gain powerful evidence of negligence. Code citations from the Department of Buildings often anchor a stairway accident lawsuit. Violations and orders to correct become exhibits. Inspectors document tread depth, riser height, handrail height, and lighting levels in formal reports. Each measurement that violates the code becomes a building block for the lawsuit. Proving the landlord knew about the hazard. Establishing notice is often the central challenge in a stairway accident case. However, multiple kinds of evidence can show an owner knew about a dangerous condition. Prior tenant complaints create a documented record of a known hazard. In addition, HP proceedings in housing court reveal patterns of maintenance violations. New York City's 311 records can also document hazards reported long before the fall. Maintenance records showing deferred repairs provide critical proof. As a result, attorneys subpoena these documents during discovery. Obvious defects also support notice. For example, a missing handrail or a crumbling step creates immediate visual evidence. Photographs taken before any repair lock in that proof. Witnesses, including other tenants, can describe how long the hazard existed. Together, each new piece of evidence ties the dangerous condition to the owner's awareness. Why a New York landlord's duty cannot be delegated. New York landlords carry a non-delegable duty to maintain common areas in residential buildings. That duty covers stairways, hallways, and entrances. Property owners cannot escape it by pointing to a superintendent or a third-party contractor. We explain how this plays out in our guide to apartment building accidents and landlord liability in New York. The law holds building owners responsible regardless of who performs the work. Therefore, defenses pointing to the superintendent fail in court. Commercial owners face the same duty in office buildings and retail spaces across New York. Both settings turn on the same core question. Did the owner take reasonable steps to keep the stairway safe? When the answer is no, the lawsuit moves forward. Common causes of New York stairway accidents. Falls on defective stairs come from a familiar set of hazards. First, worn or uneven treads create tripping dangers. Next, inadequate lighting hides step edges and height changes. Loose or missing handrails eliminate critical support during descent. Additionally, water, ice, or debris turns stairs into dangerous slopes. Similarly, torn carpeting or cracked concrete catches shoes and causes falls. Outdoor hazards work the same way. Our sidewalk trip and fall guide covers those cases. Building owners must address these conditions promptly. Because of this, delayed repairs deepen the negligence and strengthen the injured person's lawsuit. Ignored complaints often surface in discovery years later. That history can transform a single fall into a documented pattern of neglect. Damages a stairway accident lawsuit can recover. A successful premises liability lawsuit can recover substantial damages. Medical expenses cover emergency treatment, surgery, and ongoing rehabilitation. Moreover, lost wages compensate for time away from work during recovery. Pain and suffering damages address physical discomfort and emotional distress. Permanent disability damages cover lasting impairments. As a rule, New York stairway cases involving head, spine, or major joint injuries reach 6 or 7 figures. Beyond that, recovery reaches future medical treatment, mental health care, and long term life adjustments. Loss of consortium lawsuits may also compensate a spouse harmed by the survivor's injury. The law firm of Andrew M. Stengel. PC moves fast on stairway accident cases. Time is critical after a New York City premises liability injury. Evidence disappears, witnesses move, and owners often patch the hazard before anyone documents it. At the law firm of Andrew M. Stengel. PC, we handle stairway accident lawsuits across New York. Our team gathers evidence quickly, retains the right experts, and pushes for the maximum recovery. Stairways and witnesses do not wait, and neither do we. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.